Reaffirmation is the resurrection of that in personam liability. So let's go back to the car setting. Remember, my little hypothetical was you go to the dealership, you see the car you want, you don't have the cash to pay for it, so you borrow money and the creditor gets a claim against the car. You make your monthly payments. You don't make the payments, the creditor can repossess. If there's a post resale deficiency, the creditor can come after you. When you go into bankruptcy, things change. Now, you could conceivably get rid of the in personam liability and own nothing personally. Creditor would still have a claim against the car if you default, but, well, creditor couldn't come after you personally, sue you once you get the discharge. So let's contrast two things here. Outside of bankruptcy, you have the car. You're not making payments. Creditor retrieves the car, turns around and sells it for less than you owe. It's coming after you to collect the post-resale deficiency. Go into bankruptcy, and let's stick with Chapter 7 because it's simplest here. You discharge your personal liability. You don't make the payments, creditor repossesses, sells for less than you owe precisely zero. Why is that? Because your in personam liability was discharged in the bankruptcy. So the creditor can't collect from you that post-resale deficiency. Well, as you might imagine, creditors don't really like that. So they paid hundreds of millions of dollars to some politicians. Sorry, those two words are so very similar, and I get confused, partly because they are involved in the same basic line of work. In any event, they got the law changed. And now what the bankruptcy code says is the creditor can insist that you resurrect that in personam liability. Otherwise, the creditor could conceivably come and take the car back. Now, if there's a shortfall, a post-resale shortfall, the creditor will not be able to collect from you personally. So that's what's in the bankruptcy code. If you either redeem the car by just paying it off in one big payment, or you resurrect that in personam liability, then you get to keep the car, but in either case, you're going to be making payments. With redemption, it's one big payment. With reaffirming the personal liability, it's a stream of payments. Here's the wrinkle. California law was changed not too long ago, and now California law has a provision that says that if you are current on the payments, regardless of whether you've been in a bankruptcy or not, the creditor cannot repossess, even if you have no in personam liability. So now we have this interesting tension here because the bankruptcy code also has a provision that says if you don't reaffirm the debt, you don't redeem, then the creditor can avail itself of applicable non-bankruptcy law. So prior to this change in California law, that just meant, well, the creditor could come and repossess the vehicle. But with this change, the creditor can no longer just come and repossess the vehicle. So let's go back to this idea of reaffirmation. Mechanically, what happens? We file the petition. The court sends notices out to each of the creditors. Creditor gets the notice, sees, oh, you've got this car, and prepares a reaffirmation agreement and sends it to me, because the creditor can't contact you once you've filed your petition because of something called the automatic stay. And we've talked about that in other videos. You can look those videos up if you wish. So then if you sign that reaffirmation agreement, then we send it back to the creditor. The creditor's representative signs it, files it with the court, and the judge will set it for a hearing. Judges, for the most part, are loath to approve reaffirmation agreements because they don't really like the idea of somebody emerging from bankruptcy with any more in personam liability than is absolutely necessary. So as a result, quite a few creditors don't even bother preparing reaffirmation agreements anymore. This is for the Central District of California. There may be places in the country where judges are really gung-ho to approve reaffirmation agreements, but at least around here, with a couple of exceptions, the judges are not all that eager to approve reaffirmation agreements. Well, that being the case, suppose a creditor sends me a reaffirmation agreement. I can give them a call and say, well, will you let my client do a ride and pay without reaffirming? Most of the time they'll say yes. But ideally, from the creditor's perspective, they like to have the debtor back on the hook personally. So maybe you can negotiate more favorable terms. In fact, I did this just a few days ago. This was on a loan that was not a purchase money loan. My client had a car that was paid off and took out a loan against the car. This kind of a loan is sometimes referred to as a title loan. And the terms were really onerous. It was really a loan shark loan. So I called the creditor and said, there is no way on earth any judge in the Central District is going to approve a reaffirmation agreement with these terms. And we were able to negotiate a significant reduction in the interest rate and a significant reduction in the monthly payments. Client was happy, creditor was happy, and so we've sent the executed reaffirmation agreement back to the creditor, and we'll see what the judge does. There, a judge might be willing to approve the reaffirmation agreement because there has been such an improvement in the terms. But to have a reaffirmation agreement where there's no change in the terms, as I said, with a couple of exceptions, judges don't really approve those. And if the judge doesn't approve the reaffirmation agreement, there is no reaffirmation agreement.